Today, what we're going to be talking about, we rolled this out a week or two ago, and so we just wanted to make sure that we also took this opportunity for people that were not physically or even on our Zoom presentation of our mobile home contract. You may or may not know that we've talked about it for a couple of months now, that we're going to be producing a mobile home contract, and it's done, it's completed. And it's one of these forms that never in my real estate career did I ever think that was ever going to be something on my to-do list. And but the market has changed a lot, and I believe that the mobile homes might be something that each one of us may have to represent a buyer for, because this may be the only way that a first-time home buyer can actually get into a property as property values may continue to increase. So our company did go ahead and create a contract that we do want to go over briefly, and with some other documents that are there. These documents are already on .loop under the templates section. They're available to be used. And what I would strongly recommend, what we want to do, whether you represent the buyer or the seller, if you represent the seller, what we are recommending that you do is the 5 documents that we're going to briefly cover today. Download those and put those on as attachments on the MLS for your listing. And then in your agent remarks, when you're going to say, when you submit your offer, please use the attached mobile home purchase contract. That way, the buyer that is going to be making an offer on your listing uses this contract, and it's going to clarify things. And then, of course, if you're representing the buy side, and we do not represent the seller, then just use this contract and obviously make the listing agent aware of it, that it was developed, and it really is kind of designed to pattern after the REPC as much as we can. So a lot of the fields where everything, they coincide with the REPC. So Section 5, for example, talks about agency. Section 7 talks about seller's disclosures. So we've really tried to make it so it runs hand in hand with what you already know. So you're not going to have to, it's not going to be too much of an adjustment. Now, that being said, the one thing that I need to make sure that everyone understands is this is a mobile home contract, which it's personal property, and we are all licensed agents to help to sell real estate. That's what our license covers. So we're really helping people buy a car. And if you have ever purchased a car, by an individual, not necessarily by a dealership, there's a lot more paperwork that gets involved. But if you've ever bought or sold a car, it ends up being a simple bill of sale, and monies are exchanged right there with a handshake to complete the transaction. So when things are different as you're working through one of these contracts, just in the back of your mind, remind yourself, it's like buying a car. So don't get too worked up over it, but obviously you're going to have some questions, and we expect to be here for it. So Ken, any other thoughts?
No, I agree 100%. I mean, our goal was to try to, make this as comfortable as possible. That's why we mirrored the REPC. Some things may not apply in this concept. I got the question yesterday, hey, I'm listing a manufactured home, and my seller is FERPTA. What does that mean? Well, in this particular case, it means nothing. because it doesn't matter when you sell a vehicle, for example, a car or anything else, if you're FERPTA or not. So there's some things that apply and some things that don't.
That's right. Okay, we're going to just jump right in again because this is a lot of information that we are going to cover in a very short amount of time. So let me share my screen first off. What screen are you guys seeing?
It's the checklist.
Okay, that is what's pulling up. Okay, good. Okay. All right, so first off, what we got, this checklist that you see in front of you is there to help you and help you explain to a buyer's agent the process, and really it helps you quickly understand some things that are specific to the contract, that if you represent the seller, what you're going to want to fill out. If you represent the buyer, what you're going to want to fill out. So it all starts here. So as you can see, the form is broken up into two different ones. One, if you represent the buyer. So if you are representing the seller, you're going to want the buyer's agent to use this second page of the checklist specific to the buyer. If you represent the seller, you're going to be starting with this. So what we've tried to do is just take the REPC, or it's not the REPC, we've abbreviated as an MHPC, mobile home purchase contract, and we've originated from there. So the first part of it is you want to make sure that you upload all of these forms, and all of these are in dotloop at this time. So take a copy of all of these forms. You're going to want to upload it. Before you upload a copy of this checklist, you're going to want to fill it out. Okay. So there's information that's on this checklist that is needed to be filled out in order for that buyer to fill out the contract. So you're going to be entering information, for example, on the MLS, but some of the information that is on this contract will not be on the MLS. So for example, we have in number 3H, we've got a VIN number 1 and a VIN number 2. You may not have known, but if you are selling a double wide mobile home, there will be 2 VIN numbers that will be attached to that. And so you will need to include those VIN numbers on this form so that the buyer, when they fill out the contract, will have the information available to fill it out to submit to your seller. So make sure that you fill out, the same thing applies, the park address, the manufacturer's name, the model number, things that are going to be, a lot of this information you will not be able to put on the MLS. So this is almost like an MLS input section that you're going to need to provide. Then you're going to be asking you're going to be given certain questions that you need to fill out. So it's pretty self-explanatory, and we've really tried to go and give an explanation of everything that's here. When we're dealing with the seller's disclosures, there is certain information that is unique to this mobile home. So for example, one of the things that you don't need to get the actual, in fact, you would not want to get the actual title to the property to give as a seller disclosure to the buyer. You want to make a copy of that title, of that title, to show that you have it. But you, as the listing agent, you want to make sure that early on that the seller actually has it, because we hear many times the transaction's supposed to close today or tomorrow, and the seller can't find a copy of the title to give to the borrower. So this is why we put this on here, is making sure that the seller actually has a copy of this, because they're going to have to produce a copy to give to the buyer as part of their seller's disclosures. Another thing that sometimes is needed if the buyer is going to be qualifying for a loan. Sometimes the lenders that do these types of transactions, they require the last 5 years receipts of tax payments, or at least the last couple of years, to show that the owner of that mobile home has been paying their property taxes. Because if not, then the new buyer, when they go register this unit with the DMV, they're going to be charged all of those years of back taxes. So again, we want to make sure that we have copies of this stuff in order to avoid any big issues. So we're going to leave this form here right out of the gate, but we're going to go to the contract now. But this is what you're going to want to use that will help you fill out the contract, whether you are the listing agent or if you're going to be communicating to the buyer's agent how to fill out this form. Anything you want to add, Ken?
No, I think it's a great form. It's, to be able to have a checklist so that you're well organized and have everything you need is great.
Okay. All right. Is the manufacturer home showing up, Ken?
Yes.
Okay. So real quick, the document, similar to this, is actually 8 pages long, whereas the Rep C's 6 pages. And the reason why it ends up being longer is because we've tried to take a lot of, basically the same stuff that's on the Rep C, and then there are things that are unique to the mobile home specifically. So when we sat down with an attorney to draft this, we looked and asked, one of the questions is, should we be really simple, make this a 1-2 page document and be really kind of a hands-off, just like, since this isn't our area that we are licensed in, we just take a real simple approach. And the consensus came across to say, look, if we're going to dive into this, then we should be as complete as we can in order to help our clients, but also to even protect you and us as the company, that we've tried to do whatever we can to make sure that this works. Okay. And so that's the reason why we decided to go bigger than smaller. So it's got basically the information that pertains to the Rep C, but then there are some unique differences that of course are applied. The first thing that is completely different is under the first section here, deals with earnest money. Earnest money will not, the one thing that the DMV came out with 2 or 3 months ago is the DMV, I said DMV, I mean the Division of Real Estate. The Division of Real Estate made it very clear that if you are not able to put earnest money that are pertaining to a mobile home contract into your real estate trust account, because the trust account that we have pertains to only real estate, whereas a mobile home contract is personal property. So we cannot put earnest money in our trust account. So the thing that we want to clarify is really kind of in this opening paragraph, is whether or not this particular form will be used or a Rep C will be used. It says this manufactured home purchase contract is to be used when selling or buying a mobile home or manufactured home that is considered personal property and is not being transferred along with ownership of real property. A mobile home or manufactured home will be considered real property if the requirements of the Utah Code section here have been met and the ownership records are maintained by the county records instead of the Utah Department of Motor Vehicles. So if they have any portion of their land or the mobile home that is recorded with the county recorder's office, that is real property, and the REPC should be used. If it's not, and it's only title being held at the DMV, then it's personal property, and that's when this contract will be used. Regardless, from a company's perspective, what we've decided is regardless if that transaction is if that mobile home transaction is being recorded in the county recorders or with the DMV, we're not going to hold earnest money at our company. And the reason why is because it's possible that either the seller of the property believes that it's real property and you take that advice of the seller, and it turns out that it's actually personal property, and we deposit earnest money into our real estate trust account. And we're not going to do that. So in those situations where you believe it is real property and you're going to use the REPC, in that situation, you're going to want to deposit the earnest money into the title company's trust account, in which you'd have to, as it's stated here, use the deposit of earnest money trust accounts addendum. Okay, you want to make sure that you do that. But the bottom line is, if the majority of the time this is going to be personal property, you're going to be dealing with this challenge. And most title companies, if it is personal property, they're not going to allow earnest money to be deposited. So we understand that, and this is the first thing that we want to remind everybody. Remember, it's like buying a car. Rarely is earnest money ever used in buying a car. So don't get too worked up over it. You may choose as a buyer and seller not to have earnest money at all in the transaction. And you can do that. Anything you want to add?
And the biggest problem there is that if it is personal property, then we deposit that money in our trust account. That's commingling, because a trust account does be used for other people's money for the purpose of real property transactions. So that's the difficulty we have. And I believe any title company would have the same issue by definition of what a trust account is to be used for.
And that certainly may be the case. They're governed by, they're not governed by the division. They're governed by the insurance commission. So they may have different rules and regulations and what they can and can't do. So, but that will be their call. All right. Are there any questions up to this point that anybody may have? Okay. All right, let's jump in real quick. First off, as you can see, again, it's generally the same type of thing. Real quick, we added a couple of differences here because we know that we're dealing with our included items. We were able to specify a little bit more stuff that I know that you guys have a problem on dealing with the REPC. Many times thermostats, like the Nest thermostats, or certain equipment that seems to be part of the home. We've kind of answered those questions and we've got it included. So here we've got all existing fixtures and fittings that are attached to the manufactured home: electrical, plumbing, heating, air conditioning fixtures, and equipment, including thermostats. So that hopefully provides a little bit more of a clarification that if someone's trying to take that when the property's closing, we've solved a couple of those challenges with you right here. The section 2 talked about the loan requirements, if any. So nothing big. Now, the one thing that the forms that we have for this, again, we've got this checklist, we have the contract, we have a manufactured home bill of sale. And you may be thinking why this is needed. The reason why this is needed is because when the buyer goes to record with the DMV more than likely won't want to use this purchase contract, and they will want just the bill of sale as their source. So we've incorporated this particular bill of sale that you are able to use as part of the transaction. Make sure you use this one, because what this particular form does versus the one you can find on the DMV's website is it gives a little bit more of a disclosure in regards of warranties. So it ends up protecting both sides a little bit better when it comes to any type of warranty. So you're going to have that. You're going to have a generic settlement statement. Don't get intimidated by this settlement statement. Don't feel like you have to go so extreme. Heck, you may have at the very end purchase price of $50,000, $45,000 going to the seller, $5,000 is going to the brokerage for commissions, and the buyer brought in 50 grand. I mean, you don't have to go to extreme. I've put in information to help you answer questions that you may or may not have to address, specifically dealing with utilities. Remember, you're going to be acting kind of as a title company in this case, where there are mobile home park fees, HOA fees, property taxes that you've got to verify have been paid off. You've also utilities. You got to make sure that the utilities are going to be covered for those certain things. So again, we're going to go into a contract that'll tell you whether or not you're going to have to do this or somebody else is going to be doing it. And then if necessary, if your seller is going to be providing some type of form of seller financing, we did create a seller financing addendum specific for this, because it's the one form that is very unique. And so we went that extra form. We developed it specifically for this transaction because it is so unique. Every other addendum that you believe that you would need to use, let's say that you're subject to the buyer finding a property. Okay, just use the addenda that is already on the MLS that you're used to, and that will satisfy what you're trying to do. Because what we've added is in section 9 of this contract. This amendment to a form and addenda. Basically, this paragraph says that, hey, if you use an addenda that is tailored to real estate, then we put this language that anything on that addendum that says Rep C or real estate will be substituted with MHPC or personal property, so that contract can still basically apply. So still use those other form, but then just know that we're trying to look at things specifically to help balance things out. Any questions right now? Okay. So I'm going to just jump through this. Again, this information, you're going to see some things on your checklist that are going to be available to point out, but I just kind of got some things here specifically that I want you guys to see. So under the settlement and closing, one of the things that are, depending on how you're planning on closing this transaction, if the buyer is getting a loan, there are certain lending companies that they will actually act as a closing agent. Okay. And if that is the case, or, a title company or any type of an attorney, you're going to find out who's going to be closing this transaction. Is it going to be a title company, an escrow agent or an attorney? If so, well, then this is ultimately what's going to apply. And then there's going to be certain things that will be done to define what settlement is. If no escrow or closing agent is going to be used, meaning it's going to be done through you, then this is the process that needs to take place and how settlement and closing is defined. The first thing that's going to happen is under the settlement in that situation is the seller is going to have to provide certain things. A settlement statement. And that's really, and that's the reason why we have created a settlement statement for you, explaining what the process, what the cost and everything is going to be, who's paying for what, who's getting what. Okay, so a settlement statement is going to be provided. If a closing agent or the lender is going to be closing the deal, they're the ones they're going to provide that settlement statement, so you won't have to do it. Okay, you're going to have a copy of a payoff verification letter and the lien holder from the lien holder, or a copy of the title, the duplicate title that shows that you own it free and clear. You're basically just, the whole purpose of doing this is, and that checklist has you look into this information. You don't want to get to the closing or the settlement table and realize that you don't have all of the paperwork and all the stuff that you need to actually complete the transaction, because we're hearing that happens over and over and over again. They go to exchange checks, or they try to go and record with the DMV the title, and the title isn't there, or the seller didn't realize that they owed so much on the property. Now they don't have enough money to close on the transaction. So this is why we've tried to handle this in advance to make sure that this is completed. Okay. Same thing. We're still in the same area. We define when possession is going to occur. Talk about prorations. Who's paying for what? Certain special assessments, if any, are they going to be applied? Now, one of the distinct differences on where this contract exists is a mobile home park may have their own fees that they charge, and some of that stuff is going to be needing to be paid by the seller, and other things are going to be able to be negotiated. So sellers shall be responsible for any and all rents, fees, and other expenses charged by the mobile home park to the seller or manufactured home under a lease between seller and the mobile home park up to that point. So if the seller has to sign a contract with the mobile home park, there may be monthly fees that they have to pay for that. Well, the seller's going to be responsible for that portion. But any fees charged by the mobile home park to enter into a new lease, kind of like a transfer fee type thing, that can be negotiated. Either the seller pay for that, buyer pay, or they split it equally. Okay. The change of DMV fees. You know, if there's a cost to get the DMV charges, well, the buyer is going to be responsible for those fees. Okay. Of course, like anything else, buyer and seller can always do an addendum to change this and work all that out. Utility services, buyer agrees to be responsible for all utilities and other services provided to the manufactured home after settlement. So prior to settlement, the seller automatically is responsible for that. But after settlement, it's the buyer's responsibility. Pretty straightforward and simple. We've identified agency here. Okay, this is where in dealing with the title, this is where we talk about that this bill of sale is needed. Seller represents and warrants that the seller has title of the manufactured home and will convey marketable title to the manufactured home to buyer at closing by bill of sale in the form of the attached bill of sale. Okay, so make sure you use that, because that's where the seller is going to have to provide a copy of that so that the buyer can take that bill of sale to the DMV to get it recorded into their name. If there's any long-term or short-term rental agreements, make sure that the seller provide all those. Okay, under seller's disclosures, let's make sure, and I'm blowing through this really quickly, obviously, because we're trying to get this done in an hour's time. But if there are questions, please jump in and feel free to ask me. Seller's disclosures here. Again, we're going to just use the same property condition disclosures that are on the MLS. We don't have anything different, but just know that there's going to be things that are applying on those seller's disclosures that may not apply here directly to this mobile home, but still fill those out. If the mobile home was built before 1978, still has a lead-based paint requirement that you'd want to disclose. So the same requirement there. Here's something that'll be unique to the mobile home park, or the mobile home itself, is a copy of the certificate of title showing the seller owns the manufactured home, or a duplicate copy of the title. Again, the reason why we want to make sure that we know that up front is that the seller has it to be able to close on the transaction. So that's going to be one of the seller's disclosures, and we're talking a copy, not the actual title. Do not give that, just a copy, so that the buyer knows the seller has ownership in it. The copy of these last 5 years of tax payments. The reason why that's needed, again, is because sometimes with the DMV, whether it be the DMV or even a lender, the previous or the seller of the property has not been paying their property taxes. So you want to make sure that the buyer is not going to be responsible for making up that gap on, think of like a car that doesn't get registered. You see it all the time where people are driving vehicles around and it's got a 1 to 2 year old sticker on their license plate, where that owner of that car has not gone to the DMV and paid that year's taxes, but they're still driving the car around. Same thing can apply here. They haven't paid the taxes. So you want to make sure that gets done. You want to get any copy of notices by the mobile home park. If the mobile home park has notified the homeowner of any issues that are going on, well, the seller has a knowledge that they need to make sure that is passed on to the buyer if there's something that the buyer needs to be aware of. Let's see. Of course, the lease to the property with the mobile home park, any written explanation or notices or demands that have been issued, whether it be through the association or through mobile home park. Again, you're just trying to provide the buyer with all the information that the seller may have received. Okay. Now we go into our due diligence. Now this is where there's a couple of things that are unique with what we have here. We're making it very clear that the buyer understands that no real property or any lease of real property is being transferred, assigned, or sublet with this mobile home. Buyer also understands that buyer may or may not be able to keep the manufactured home in its current location. In the event that buyer elects to waive buyer's due diligence, buyer does so at his own risk. So what we're talking about under this section, you may or may not be aware that if a buyer submits this offer, they're going to, under this section 8.4, the buyer is going to have within 5 days or whatever days specified here, that they have got to go and make an application with the mobile home park to see if the mobile home park will accept them as a future owner of the property. That mobile home park can reject that application. So if the buyer, by chance, waives their right to their due diligence, well, they're in essence also potentially waiving their right to get this application approved. Okay. The other thing that the mobile home park has the right to do and the buyer's going to have at least within 5 days or less or whatever to find out if they've got if it's going to be accepted. Is the mobile home park they might be updating their standards of what they want in the mobile home. So they could come back and say, all right, buyer, you are under contract on this property, or you bought this property. But if you do not meet these standards, then that mobile home is going to have to leave the park. So the buyer's going to have a right to find out if the condition of the property meets their standard, or if it's going to have to be removed before they go under contract or close on the transaction. So that's part of the buyer's due diligence, and we're making the buyer aware that they've got to do this. If the buyer does waive their due diligence, what we've done is basically just said, look, the only damage to the buyer in that case would be the earnest money. Now, I understand that buyer and seller may choose not to have earnest money on the property, and so if that's the case, there ultimately is no damage to the buyer. So you just need to make sure that you understand when you're working with it on the transaction exactly where you want those damages to come into play. But again, don't get too worked up over it. If you were to buy a car and you had the right to go take the car to a dealership and get the car inspected, and your mechanic came back and felt that the car was a lemon and not to buy it, the buyer comes back and gives the car back to the guy, and there's no harm, no foul. So don't get too worked up over what is done or is not done. Ken, I don't know if you have any added thoughts.
It's just really important that if you're the buyer's agent, that you're informing them of these things that may be potentially an issue. The mobile home park, at least the experiences that I've had, have been pretty stringent on who they've let in the park. They do a criminal background check. They don't want somebody who has a criminal background, especially a violent background, in the park. And they also do a credit check, because they're obviously going to have to be responsible for the monthly fee for that space. And so they want to make sure the person has a decent credit. So there is a test that comes that way with the new occupant. Also, I personally had a situation this last week where I had a seller approach me about listing their mobile home, and the park did impose some new standards on the community, which meant that there was going to have to be about $10,000 worth of upgrades on the exterior of the trailer. And it's a good thing we knew that before we listed it, because that's all got to be done in order to have the new buyer approved as a tenant in the park. So those things do come up.
Thanks for that insight. See, the one thing that I'm glad that Ken's here for is he's actually represented a buyer or seller on a mobile home transaction. I truly never have, and nor do I plan on ever doing it. But that being said, these are the things that we need to be aware of, because thankfully we are aware of this stuff, and we're able to put it into that contract. And
well, I was licensed for 29 years before I did, so it's a recent phenomenon. But to your point earlier, this is where the affordable housing is. It's going to become more and more common for us to be approached to help people with this, because it's not an outlier anymore. Because of the cost of real estate, I mean, these homes now are knocking $100,000 or more for a manufactured home. So this is the affordable housing in our industry. So we're almost going to be forced to have to deal with it. So we're actually a little bit ahead of the curve, I think, because I think this is going to become more and more common.
I agree. I agree. Okay. Let's see here what we got here. as you can see, everything else here, a lot of it is, again, same paragraphs, specifically like, section 10, where it's talking about the obligation of disclosure. Same thing that exists in the Rep C. Just if a buyer waives the due diligence, that doesn't waive the seller's obligation to disclose information that they know about the property. Or if the buyer and seller waived section 7, seller's disclosures, this is the part that is so misunderstood. People think that if like when an investor is flipping a property and they decide that there's no seller's disclosures that are going to be provided, they think that exonerates them by waiving section 7. No, the law still requires that the seller has to disclose any material fact that they know about the property. So that's the same thing that we've still got here, and the same obligation for our seller. All this stuff is really very similar, but again, mobile home park leases. As a simple reminder, remember on a mobile home, one thing when that buyer goes to the DMV to record this, remember they're going to pay taxes. So they're to get this park registered. So here the buyer is buying a property for 80 grand or whatever, and then they're going to go to the DMV and record this. There's basically a sales tax that they're going to have to pay again. So just remind your buyer that there's an added expense that they're going to have to do in order to get this completed. All this stuff is basically the same, but you can see, again, the same paragraph numbers. So hopefully it's not too confusing using this versus going to the Rep C. But I highly encourage you to still read this. There are some subtle differences. Now that checklist covers all, if not most of them, but just make sure you read through this to answer any of those questions. The last thing that we put in this contract is, again, reiterating professional advice. We are not in the business of selling personal property. We are licensed real estate agents to help facilitate a transaction. So we're not attorneys, we're not accountants, we're not contractors, we're not mobile home specialists, we're none of that stuff. And so if the parties feel like they need additional advice, then this is reiterating that they are strongly encouraged to seek that counsel versus relying upon anything that we may or may not say. That's very important in doing this. We're not trying to scare anybody away, but we're being asked to help deal with something that's sometime close to working on a home. It's like buying a trailer that has the capacity of sleeping in, but it's still, again, personal property that's being issued. And then same thing, obviously adding for signatures and everything else here. So this really is kind of the gist of what it is. Just remember, still make sure we have the bill of sale, which in order to do that, that's going to be more than likely be notarized. So the title company, North Star Title, they've got notaries that are there that can do it. So make sure when you're signing this stuff that you've already lined up a notary that's going to be available to witness that this is done. But then outside of that, that's really kind of the gist of it. I know it may look a little bit intimidating, but I think if you read through everything, you'll find out that it is pretty self-explanatory. And hopefully, and by the way, you're going to get asked over and over again, was this contract created by an attorney? And the answer is yes. So with our license, we have a license that gives us the right to use state approved forms or contracts that are drafted by an attorney. So we're covered in this area that this was drafted by an attorney that, and so if the buyer's agent is concerned or their broker's concerned about using this, it was completed by an attorney, and this is obviously our company document. I know of only one other company that I think has gone out and created a mobile home contract, and they've gotten a little more simple. And anybody venture who that might be?
No.
It'd be Remax, since Matt Barton. Matt and I, we were working on this before Matt left. And so I don't know if they've got theirs finalized or not, but there is one other company that has a mobile home contract, or at least will have one. But otherwise, the majority of the market, my guess is this contract is going to be used a lot in the industry because we've pioneered it and started it. Other companies in the future may do something similar, but yeah, this is our contract that we've created for you guys so that you can be more successful and represent your clients and protect yourself and the company the best way we know how. So any questions to this as we're
There is a question in chat. Shauna asks, do these forms apply to a manufactured home on a permanent foundation sitting on owned land?
So if that owned land is the owner of that property has that land with the county recorders, and they have this parked, but it is attached to it. It is not movable. It is more than likely that would be what would considered as a real estate of the transaction. And you could just use the rep seat in that situation. But again, our company will not receive earnest money on that type of a deal. But if that land is owned by the mobile home park or whatever, even if it appears to be attached or fixed to some extent, if it's recorded with the DMV, then it would be personal property.
And then also, just FYI, I put in chat the name and phone number of a lender that specializes in these kinds of transactions, just for your reference. So if you guys are wondering who finances these kinds of properties, there's one source for you there in the chat.
Oh, that's helpful. That's great.
I have a question, Rob.
Yeah.
I'm in the middle of a mobile home transaction and I'm representing both parties. So I'm a limited agent.
Okay.
And we had multiple offers, so now the appraisal has come back because they are financing it. And I'm wondering if this falls under, seller wants to know what it appraised for. I can't disclose that, correct?
No, that's the buyers. That'd be no different than in any other transaction.
Okay, I just wanted to make sure.
Yeah, so
because
just
they're answering to more people as far as, other family members, and everybody, of course, thought we undersold it. We did not. And they want to, have proof that we did by knowing what the appraisal is. And I think that just is a can of worms. I just wanted to make sure I don't have any obligation to disclose that.
No, now, I mean, if the seller is asking you to go and ask the buyer if the buyer is willing to release it, then yeah, you'd have to go ask the buyer if they're willing to do that. And in past experiences, I know if I represented a buyer in that situation and the home appraised for far more than what it was sold for, I'd tell my buyer, I would not recommend doing this because this could cause the seller to get upset and want to just kill the deal because they feel like they're leaving money on the table or whatever it is. But if the appraised value is close, if not at price, then I would still just I'd say, sure, I'm willing to allow the seller to have a copy of it if they're willing to pay the buyer money for it. Buyer had to pay, get the appraisal as well. So why should the seller get a copy of it?
Gotcha. Okay,
That's just
I just
my
wanted to make
opinion.
sure on that.
So there's another question from Ellery in the chat, and it says, from a compliance standpoint, will a file be held and not sent to accounting if the bill of sale is not notarized once we receive funds?
The answer to that I'd say would be no at this point, because I know that the DMV sometimes will do that internally. Sometimes the DMV does not require the notaries on it, but we're not going to be the checks and balance. I don't want to convey that. That's an internal question that we can just resolve, but in general, probably not.
A follow-up onto that question would also be, if the seller's agent or if the seller provides the DMV bill of sale rather than our bill of sale, is that acceptable?
That will work. Again, it's similar to what we would say that if you use, from the company's perspective, if you used a buyer broker that's on the MLS versus using our company buyer broker agreement, is that acceptable? The answer is our company policy is we want to use our company buyer broker agreement because it has more protection than what's on the MLS. But I'm not going to kill a deal or prevent the thing from moving forward if the one on the MLS is used. It just doesn't provide as much protection for you or the client or the company.
So there's another question.
Here.
There's another question here from Gregory, and I'm not sure what it's in reference to. Maybe when we were talking about personal property transactions, and maybe he can unmute himself and clarify. But the question says, title doesn't provide a policy of title insurance, right? So he's basically saying the title company does not provide a policy of title insurance. And that would be if it was deemed as personal property versus real property.
So Greg's still there. If you're asking, does a title company offer title insurance for manufactured homes? And the answer is no when it's a personal property. If it is considered a real property on the land portion, that title policy will only be on the land, and then you would have to get a separate owner's policy on the structure itself. It's kind of similar to a trailer, an RV or whatever. You got your own RV insurance. Did that answer your question, Greg?
Yeah, that was it.
Okay. Anything else? Well, hopefully this is going to be, Ken and I both expect we're going to have questions about this because this is new to everybody, myself included. And there's going to be things that are going to come up that we never thought of, and it's going to be a work in progress. But hopefully this helps you see that this is a good starting point with what we've got, and hopefully puts you ahead of anyone else that you're competing against. So if there's nothing further, we appreciate your time, and we will talk to you next week.
Great job. Thanks, Rob.